Kristen some more details, because there are, if we're reading this right and if we're reading it wrong, they give us some additional information so that we can better direct you on how to help the person that you're assisting. Is that a fair?
Yeah, especially with the follow-up, because I saw she was unaware the eviction was filed until it came on, oh right, so it is a DV situation. Yeah, so that question I would say it is probably helpful for you to reach out to me directly or have the person go through the intake line to do that, just because if it's something where they weren't living there or whatever is going on, then there's probably a really good argument for why that should be expunged.
We have another question here about how long does the process take from start to finish?
Sure. So that is actually fairly county specific, not to give really wishy-washy answers on all of this, but I would say it really depends because it just gets set on the regular motion calendar. So here in Ramsey County, because that's a pretty backlogged, we're pretty far in the hole as far as motion stuff is concerned, that can end up being it's definitely shorter than criminal expungements, I will say, which we'll get to, but it can still end up being, I would say, for when I file it, it's probably another 6 to 8 weeks until I actually get a hearing. I will say Dakota County and some of the smaller counties are just like less, backlogged, that it can be maybe 2 weeks. So I would say that the shortest amount of time, it would be at least a week, just because you have to be able to, they want time for you to be able to mail that stuff to the landlord. But I would say I've never had it set out more than 2 months on our busiest, so it's probably in that range. Again, definitely quicker than the the criminal expungements, but it really just depends on what the court's calendar is like.
Heidi, do you see anything?
Anything else?
All right.
All right, so we will also hopefully have some time at the end to take questions. So if something pops up, please, let us know, and we'll also take some questions at the end. So again, my name is Megha Sully. I'm an attorney as well as Smurls. I'm actually a government benefits attorney, and then I also do criminal record expungement as well. I'm not really sure how the two relate, but that's kind of the practice area that I'm in. So to start off, I just want to talk a little bit about what do we mean when we're talking about criminal records. Records are created at nearly every contact with the criminal justice system. If you're arrested, there's a record of that. If you are charged, there becomes a court record. If you plead guilty or found guilty, there's a record of that, and then you could be referred to probation. If you spend time in jail, there's a record of that. So when we're talking about criminal records, we are talking about the paper trail that is created when you have contact with the criminal justice system. And there are many different agencies that maintain these records. You have the Bureau of Criminal Apprehension, or the BCA, the courts, the police, the sheriff, city attorneys, the Department of Human Services, the Department of Health, when it may relate to DHS background study. And then you also have these private data companies that are collecting records and selling these background checks. I think that there is a misconception that we all have, there's some big filing cabinet out there with our records on it. You can put someone's name and pull it out, and there's our record, our criminal record. And that's just not the case. There are records that all these different agencies have. And so when we're dealing with criminal record expungements, what we're looking at is who has the record, who's making it available, and kind of what the harm is doing. I also think there's some misconceptions on how long records are available to the public. So, for example, the Bureau of Criminal Apprehension, or the BCA, that agency keeps records available to the public for like adult convictions for 15 years, and that time period starts from the date the individual completes their sentence. So that's one agency that may have records available. However, the court system, those records are available basically forever. Even if the charge is ultimately dismissed, that record is available to the public, pretty forever, which is why a criminal record expungement can be pretty helpful. So what do we mean when we're talking about a criminal record expungement? So expungement, kind of like what Kristen was talking about, is the process of going to court to ask a judge to seal a record and prohibit future disclosure of the record. In the criminal record context, actually in the eviction context as well, the court only has the authority or the ability, the power to order government agencies to seal records. They don't have the power to order these private background companies to seal records, even though there is a way to go about and get those records off once it's been expunged. But I think it's important to keep in mind that when we're talking about this process, we're talking about judges ordering other government agencies to seal their records. Another misconception is that expungement somehow means that the event, once you get it, the event didn't happen. And that's not the case. Expungement doesn't erase the record, eliminate it, or destroy it. Really what it's doing is sealing the record. It's preventing it from being disclosed to the public. It still exists. It's still out there. It's just, it can't be accessed by the public. And in some cases, even after you get a record expunged, it can be opened. For example, adult records that are expunged for convictions can be opened for purposes of future criminal investigation, prosecution, or if probation needs to look at it. If someone gets a record expunged successfully and then they become an applicant for a peace officer position, that can automatically be opened as well. So it's important to keep in mind when you're working with individuals, and I always try to make sure my clients understand me, that we're not eliminating the record, we're just sealing it and making it not available for others. But in a housing context, generally a criminal record expungement is going to seal that record in a way that will help someone get housing by making it not available to landlords. Okay. When we're talking about criminal record expungements, there's really 4 different areas, and I'm going to spend most of my time today talking about statutory expungement. That's the 4th one listed there, the 4th bullet. Now, statutory expungements refer to adult criminal records, so criminal records of someone when they're adults, when they've been charged with a crime. But we have 3 others. We have return of arrest records, which I think is a really handy tool. So if you're working with someone who is arrested but is never charged, in most circumstances, they have a right to request a return of those arrest records, which is basically what it does is it expunges the record. I know it says return. No one actually gives you a record back. That's just a term that's used in the statute, but it really is a way of getting rid of the arrest record. Now, this is for people who are arrested but never charged, and basically what they do is they can send a letter, and then it gets rid of, the record is expunged. We also have inherent authority expungements. Inherent authority expungement in the criminal record context is just a fancy legal way of saying court records only. So this would be an expungement where you are only asking the court to expunge the records held by the judicial branch or the court records. We also have juvenile record expungements. So these are individuals who have gone through the juvenile justice system, can ask for those records to be expunged as well. So just briefly, because I'm not sure how often this is showing up in a housing context, juvenile records preventing someone from getting into housing. I have seen it, but I have not seen it frequently. I think usually we're dealing with records of individuals who have contact with the criminal justice system when they're adults. But just to keep in mind what the court looks at if you are doing a juvenile record expungement, they are looking to see if the benefit to the individual asking the subject outweighs any detriment to the public and public safety in sealing the record. So for lawyers, we're looking at weighing two different interests, the interest of the individual on why they want that record expunged and what benefit they would get to them. So in the housing context, someone maybe is chronically homeless and they, and also thinking about individuals with mental health. We know that if we can stabilize them in stable housing that they can afford, we will be improving their quality of life and hopefully helping them to stabilize their mental health as well. And so that could be an example of a benefit, and then the judge would look at whether that outweighs any detriment to the public. So that's just briefly juvenile records expungement. I would say that if you are dealing with someone with a juvenile record that's actually is making it difficult for them to find housing or maybe employment so that they can afford housing, please contact our office. Even if you are working with someone outside of our service area, I would encourage you to contact us so I can get you in touch with someone, because I really think that those are cases where if enough time has passed, someone who's made a mistake as a juvenile should really look at getting that expunged.
I have a question.
Sure.
Here in the studio about the arrest record, return of arrest record. Is a landlord able to see that through the screening companies, and are they able to use arrest records? Would they see arrest records on a housing background check? Without, if they're not charged, but they have arrest records?
Well,
are those public? That's public.
It can be public. They are more difficult to get.
Right. They don't show up on tenant screening reports.
No, that was the question.
Yeah, I mean, they can be accessed otherwise, but on a tenant screening report, it's only convictions, UDs, sometimes there's like credit history, but otherwise it does not show just arrests.
Or dismissed charges.
Or dismissed charges. Okay. No, it's just as like, yeah.
All right, thank you.
And the tenant screening reports are national, not just state, correct? Even with evictions.
Yeah. The thing to keep in mind of like any private company that's doing background checks is there's no consistency from company to company. As they're private companies, it depends on, I guess, the service they want to provide and how much they want to pay and how much their customers want to pay to get it. So with arrest records, they are available to the public. If you had someone's date of birth and name, you could go down to a police station and give them that information, and they could give you that. I mean,
I have never seen it on a tenant screening agency report, but it could, I mean, like you said, most landlords will only pay to use some of the really large national ones, and I've never seen it on there, but that doesn't mean it couldn't be, in the future.
Sure, yeah. Excellent question. Okay, so now we're going to talk about statutory expungement. This is basically a record created when the individual is an adult. It's the most common type of expungement, I think. I think it is the gold standard in the sense that it gives people the most relief. I will frequently refer to it as full expungement. So we're talking about all government records held. So what I want to walk you through now is what I do when someone's in my office, the kind of the process that I go through. So when someone comes to my office and we're looking at, let's say, getting expunged, a frequent one that I see is misdemeanor theft. And they've pled guilty to it. The first question we have is, are you eligible to file for that criminal record expungement? And the first thing we do to answer that question, are you eligible to file, is there a waiting period? And that waiting period is the time you must wait before you can file. It basically has to be you have not been convicted of a new crime for X number of years since the discharge of your sentence. You may also refer to this, you've been off paper for so many years. Luckily, there are some cases without waiting periods. Unfortunately, I don't see them as often as I would like. One of them is controlled substance offenses prosecuted under a very, very specific statute. So these are usually first-time drug offenders, and they defer prosecution, and then the case is ultimately dismissed. So there are no waiting periods. So once that case is dismissed, that person can go into court and petition for an expungement. Someone who is a juvenile, but they are prosecuted as an adult, once they've completed their sentence, they can go forward and request an expungement without a waiting period. There's also then the last and probably the most common one that I see is cases that are resolved in favor of the individual. So this would be any type of case where there is no admission of guilt, no finding of guilt, no admission to any facts on the record. That is considered a resolved in favor case. This can get a little bit complicated because I think that sometimes people or sometimes clients will admit to some facts on the record, or they'll enter a guilty plea, but then they serve probation for X number of years and the case is dismissed. That is not considered resolved in their favor because they admitted to something. And a lot of times they have to do that in order to get that deal of having it eventually dismissed. So that is not considered resolved in favor. And if right now your head is spinning and you're saying to yourself, how am I ever going to figure out if something is resolved in their favor, then I would encourage you to email me, and I'm happy to do that analysis for you. But we'll kind of go through some examples. So back to where I started with the waiting period. So these are cases with waiting periods, kind of give you a sense of them. So if someone has a stay of adjudication, or maybe they go through a diversion program, the waiting period is 1 year, and it's 1 year from the date that they complete that program. For petty misdemeanors and misdemeanor convictions, it's 2 years, and the 2-year period starts from the date that they complete probation. For gross misdemeanors, it's 4 years, and again, that starts from the date that the individual completes their probation or their sentence. For felonies, it's a 5-year period, but they do have to be on a specific, the felony has to be on the list of felonies that is eligible to file, and I'll talk about that. And there are some cases where expungement is prohibited. These are any cases that requires registration as a predatory offender. Sorry, we just got a question. Does SMERLS have this list of waiting periods listed on their website for clients and caseworkers to access? We do not. You should be getting the PowerPoint. And so, my understanding, you get the PowerPoint.
No. There will be a way to access the PowerPoint.
Sorry, there will be a way to access the PowerPoint, so you should be able to see my slide that has it right here. And I don't believe that there is an info sheet on Law Help. I would say, though, if you are ever wondering whether someone is eligible to file an expungement, they can do an intake for our office. You can email me. It can get a little tricky, and we'll go through some examples, but we don't have the waiting periods on our website.
Okay.
One thing I want to say about the waiting periods, and this is why probably one reason we don't have it listed on our website, is that this analysis of whether someone can file or not can get tricky if people have multiple convictions or multiple contacts with the justice system that maybe they need to expunge. And these waiting periods are relatively new. This is a new law as of 2015. And unfortunately, the legislature was not crystal clear when they wrote the law. And so there's some litigation going through our court systems. There's already been some litigation to interpret that law and what these waiting periods mean. And specifically, what does it mean when someone has multiple convictions? What we know and what it basically runs down to is when do those waiting periods start and end when you have multiple convictions? What we know so far from the Court of Appeals, even though it hasn't all been resolved completely, is that you can start that waiting period or the look-back period from the date you file that petition. So if you're looking at expunging a misdemeanor, you want to start from the date you file your expungement petition, look back 2 years, because 2 years is the waiting period, and in that time, that 2-year waiting period, have no other convictions, and then you would be eligible to file. So the key with the waiting periods is that not just that you have to be off probation for that period of time, but you can have no other convictions, and that can unfortunately cause some people some difficulties. So we're going to go through some examples, because conceptually sometimes that can be hard to wrap your mind around. As I mentioned, only convictions for felony offenses that are listed in the statute are eligible for expungement. And this can be regardless of how much time has passed. Things that are on, so in order to get a felony conviction expunged, you have to meet that 5-year waiting period, so no convictions in a 5-year waiting period from the date that you were released from probation. And it has to be on the list of felonies in the statute that are eligible for expungement. things that are not on the list, it's easier to say that than I think things that are on the list. Things that are not on the list that I frequently see: terroristic threats, assault, felony level assault, felony level burglary, controlled substance crimes in the 4th, 3rd, 2nd, and 1st degree, so only 5th degree controlled substance crimes. For thefts or like credit card fraud, they look at the amount of the theft or the credit card fraud, so that could potentially be off the list or not on the list. So again, this list does not apply to petty misdemeanors, misdemeanors, gross misdemeanors, resolved in favor cases. So, you know, someone was charged with a felony but it was dismissed, this wouldn't apply. Or if someone was charged with a felony and did a diversion case or a stay of adjudication, the list wouldn't apply. And why this is important for this felony issue is important for housing is, one, we know that a lot of landlords say no felonies and then they don't want to rent. But the other issue that sometimes comes up is, if you're not eligible to file for an expungement under the statute, you could do what I mentioned briefly, is you could do this court records only expungement and ask the court to expunge their records based on the court's inherent authority. The problem, though, with doing that from a housing standpoint is that felony record is still going to be available to the public through the BCA. Because if you only ask for court records expunged, you're not getting all those records out there that landlords can potentially look at. And landlords, through those tenant screening companies, do get records from the BCA. So when we're talking from a housing perspective, if you're trying to get rid of a felony and it's not eligible in the statute and you try to do court records only, it might not be a great remedy for housing.
We have several questions that came in.
Sure.
If a court dismisses a charge, is the likelihood increased that the court will expunge it? And is there a waiting period for dismissed cases to get expunged?
The answer to that question is, and the question again is, if the court dismisses the charge, is it more likely that the individual will get the expungement, and is there a waiting period? The answer to that question in good lawyer fashion is it depends. It depends on how the charge was dismissed. So, for example, if the client is charged but admits nothing, and let's say, for example, the prosecutor dismisses the charge or agrees to dismiss the charge, that's great, regardless of what they were charged with, felony, misdemeanor, gross misdemeanor, they can file for an expungement. They're eligible right away. There's no waiting period. We consider that resolved in favor cases. So, again, if the charge is dismissed without any admission of guilt on the individual doesn't admit guilt at all, then there's no waiting period and they can file right away. And I don't think that there's any reason to wait to file, by the way. I get that frequent question right away, should we wait for a period of time after the charge is dismissed? And my answer is no, get in there right away and file that expungement. And that, I've been successful, at least in Ramsey and Dakota County, with that. Now, if the charge is dismissed after a stay of adjudication or a diversion program, then the individual has to wait at least 1 year from completing either the stay of adjudication or the diversion program. So in those cases, when you pull up misses, you're going to see that the charge is dismissed. But because usually to get in a stay of adjudication or go through a diversion program, you have to admit either to the facts of the case or you enter a guilty plea. There's some admission of guilt there, and so there is that waiting period of 1 year.
Can failure to register offenses be expunged?
The question is, can failure to register offenses be expunged? The answer is, if by failing to register if you fail to register, you then have to register for a longer period of time. which then I think the court is going to read that under the prohibition against expungement of offenses that require you to register. That was a very convoluted answer, but I think it's a straight way of saying that you're not going to get those offenses expunged.
Are felony DUIs able to be expunged?
Felony DUI is not on the list of felonies that can be expunged.
What about felony assault that's dropped to a gross misdemeanor after 3 years?
Sure, that's a great question, and that addresses kind of one of the gray areas in the law that the courts had to do. So again, the question is, if a felony offense that is dropped to, let's say, a gross misdemeanor, and I can't remember the question if they said a specific, but one that you see frequently is like a 5th-degree controlled substance crime. Someone's charged at a felony level. They enter usually it's called a stay of imposition. What that means from a legal standpoint is the court is staying the imposition of the sentence. The court is not going to impose the sentence that's associated with the felony. Usually what happens, at least in 5th-degree controlled substance crimes, and this isn't every case, but most of those cases, that individual is on probation for 3 or 5 years. They successfully complete that probation, and then the court reduces the final disposition from a felony to a misdemeanor. Now, this was a gray area in the expungement law. It was litigated. It went up to the Minnesota Supreme Court. Unfortunately, the court said that we are going to treat those cases not as a misdemeanor for expungement purposes, but as a felony. So when you're dealing with someone who has been charged with a felony that ultimately is dismissed after successfully completing, or excuse me, let me start over. I misspoke there. If you're dealing with someone who has a felony charge that is eventually reduced following successful completion of some type of sentence or probation, the court, for expungement purposes, is going to treat it as a felony. So then you have to go and look to see if it's on the list of felonies that can be expunged. Okay. Keep the questions coming. I know this can be difficult. So a couple of other things that I look at when someone comes into my office, not just are they eligible to file, because that's just kind of the first step when it comes to criminal record expungement. Because being eligible to file doesn't mean that the individual is going to get the expungement. We also kind of look at the merits. We look at why they want the expungement. So here are a couple of things that I consider that I think are important to think about when you are trying to decide whether expungement is a viable remedy, a good way to help individuals who may be facing barriers to housing due to their criminal record. The first thing is, why is that person seeking a criminal expungement? This is not post-conviction relief. So if someone's coming in to my office and they are coming, they want an expungement because they feel that the system is unjust. The public defender they had was not great. The judge, had it out for them. They're innocent. I didn't do this. I just had to plead guilty to move on. I do not doubt that it is quite possible that all those things are true. And our system, unfortunately, our criminal justice system, is not always just. Unfortunately, expungement is not the opportunity to get what we call post-conviction relief. What you need to do is accept responsibility and move on. Because part of the thing that the court is going to look at when you file the expungement is your rehabilitation. Have you rehabilitated? So expungement is not post-conviction relief. So that's kind of something I look at. The other thing we want to look at is expungement the most effective remedy? Is there an alternative solution? From start to finish, an expungement can take anywhere, a criminal record expungement, anywhere from 6 to 9 months. I frequently am speaking to individuals who, for whatever reason, need to move, or they need to place a voucher in the next 60 or 90 days or 30 days, and they're having a hard time finding a landlord to rent to them because of a criminal record. Because of the time that it takes to complete the criminal record process, criminal record expungement process, that's not going to be an effective remedy to help them place their voucher in the next 30 to 60 days. There is a filing fee as well, $325 in Ramsey. It might be a little bit lower in other counties. It can be waived, so you can file a fee waiver. You know, the other thing, what I look at is if they are eligible to file, what is the likelihood of success? There are factors that the court is going to weigh. The two biggest things that I think courts look at are what is the harm that you're going to suffer or what you have suffered because of a criminal record expungement, and what are your, because of the record being public, and then what are your efforts towards rehabilitation. So if someone comes into me and says they want to expunge a conviction because of they're worried that when they go to find housing, they're going to get denied. A worry that you're going to get denied when you're trying to find housing is hypothetical harm, and courts will likely say you need to have suffered real harm. Now, for those of us who are on this webinar in this room, we know that if someone has a criminal record, it makes it difficult for them to find housing. So when people come in, basically what I tell them to do is go apply for housing, just once, get denied, and then come back to me. If someone comes to me and let's say they have, and I do see that there's some questions, so I'll get to those in just a sec. If someone comes to me, for example, and they say that I want to expunge controlled substance crime, really the first question I'm going to ask them, because that's the first question the judge is going to ask them, is, are you sober now? And if you're not sober, what are you doing? Or what efforts are you taking to remain sober? And please don't take this that says that you have to be sober, or because I think we all recognize that addiction can, is something that people are going to be constantly struggling with and constantly working on, but you have to be showing some type of effort. So those are just generally some things that I look at. And I'm just going to pause for a second because I see that there are some questions. Let me just make sure I can get them all. Okay. Can drug charge be expunged? Again, whether a drug charge can be expunged depends on several factors. It depends on the level of the offense. If it's a felony level offense, first, second, third, and fourth controlled substance or drug charges, and then ultimately convictions, cannot be expunged. So on the felony level. So if you have to look to see the level of the offense and to see whether they've waited that waiting period. Again, though, if someone's charged and ultimately they dismiss it, then you can file at any time.
And so fifth, you're saying is?
Yes.
Can you give us anecdotal, what's a first-degree felony drug offense? Is someone stealing something probably? Is that a large amount of drugs? Yes. Okay, just to give us the... I'd have to look at the statute to tell you the exact amount. So fifth is less, fifth may or may not be, it's just the type of drug often, those kinds of...
It has to be amount. It has to be the amount, and I have to tell you I don't know it because we only see these on the back end once it happens.
Sure, you don't have the whole story.
Yeah.
Right, okay, thanks.
Yeah. Do you know off the top of your head what the amount is? I don't know either. Yeah. Sometimes the level of the offense, like the degree, has to do on how many times you've been arrested as well or charged. There also the question is, where would a person go if their record is in a different state? So each state has different expungement laws. Each state, in some states, expungement isn't even an option. So usually what I tell an individual to do if they contact me to say they want to get a record expunged in a different state is to call the courthouse where you initially were charged and ask, or get in touch with the legal aid office in that state. That's really the best advice I have to you because every state has different expungement laws and different levels of relief. A lot of people ask me about records in Illinois. The Illinois Public Defender's Office has a state public defender's office. If you just Google Illinois State Public Defender criminal record expungement, they have a really useful website that kind of walks through the process. So you have to go to the state where the person is looking, where the record exists, and usually the best thing is just call the courthouse and ask the clerk, and hopefully they can direct you in the right place. Did I miss any questions? All right. Okay. So I just want to walk through a couple examples about kind of the eligibility under the statute to give people an idea. So if this person walked into my office today, they tell me that they were convicted of misdemeanor theft on August 15th, 2014. They served 1 year probation. They were released from probation 1 year later in August of 2015. They've had no subsequent charges or convictions. So this person is eligible to file. It's a misdemeanor theft. So we're looking at a 2-year waiting period. That waiting period starts from the date you complete your probation, and if you've had no charges or convictions during that time period, then you're eligible to file. So this person is convicted, same example, but we're going to change the facts again. So we have misdemeanor theft, convicted on 8/15/2014, served 1 year probation. They were released from probation on 8/15/2015, so 1 year later. But then they're convicted of disorderly conduct, a misdemeanor, on 7/15/2017 and ordered to serve 1 year probation, which is pretty common, I see, with disorderly conduct. You serve about 1 year unsupervised probation. So this individual is not eligible to file. And I would tell them that they would have to serve out that probation for disorderly conduct, and then the 2-year waiting period would start over. So I would tell them we are looking at, if they successfully complete that 1 year probation for the disorderly conduct by July of 2018, I would tell them to come back to me in July of 2020 to look at expungement. All right. I see that there is a question. I'm going to go through these examples, and then I'm going to answer that question. So, all right, here we have charged with misdemeanor theft in 2016. You receive a stay of adjudication, which usually means 1 year probation. Successfully completed probation on 8/15/2017, and then charge dismissed on 8/15/2017, so 1 year later. So again, as kind of to some background, again, a stay of adjudication usually means that someone admits to it, whatever they've been charged with. So in this case, misdemeanor theft, they admit to it, but then after they complete probation, it's dismissed. So in this particular case, we have someone then that's subsequently charged with disorderly conduct on 1/15/2018. So are they eligible to file? So if this person comes to me today, they would not be eligible to file. And this is where I'm going to explain it to you, and you're going to say, but Megan, this doesn't make any sense. But I'm sorry, this is how it is. So when we're dealing with stays of adjudication, so the case has been dismissed, the way that the statute says that you have to wait 1 year and you cannot be charged with any other crime during that period. The key there is the word say charged. For all other waiting periods, it's convicted. So if you're charged during that 1 year period, regardless of the outcome of this disorderly conduct case, if it's ultimately dismissed, it still starts that 1 year waiting period all over. This is like a little bit of a nuance in the law. And again, I encourage you to email me with questions about eligibility to file. But the answer would be this person is not eligible at this time. Okay, so this individual is convicted of a 5th-degree controlled substance crime on 8/15/2010. They have 5 years of probation. They're released from probation on 8/15/2015. No subsequent charges or convictions. If this person came to me today, I would say that you are not yet eligible to file. For felony convictions, it's a 5-year waiting period. 5th-degree controlled substance is on the list of felonies that can be expunged. but you have to wait 5 years. That 5-year waiting period starts from the date you're released from probation. So this individual would not be eligible to file until August of 2020. I do want to say, though, that when people come to me who are not yet eligible to file, I tell them it's okay right now to start working on gathering your evidence. So I tell them, keep track of if you're denied jobs, if you're denied housing, start a file and just keep track of it. Write it down. Keep those denial letters from landlords. Keep those denial letters from employers. And keep track of what you're doing for your rehabilitation efforts. Because even though it's too soon, at least in this particular case, this person's coming to me mid-2018. We're, 2 years out before they can file. A lot can happen in 2 years that you can really help build up your case. And so for those of you who are on this webinar who are case managers or, social workers, ILS workers, or supervising people that are providing support to people in the community, a great thing that you can do is help people who aren't quite eligible to file an expungement yet, is keep building that evidence. That's a great thing that you can do. Okay, and I think we kind of covered this already, but same situation, except in this particular case, the conviction is reduced to a misdemeanor. Again, even though the case is reduced to a misdemeanor, for expungement purposes, the court's going to look at it as a felony. So this particular person is not yet eligible to file. They have to wait 5 years from the date they complete probation, which is going to be in August of 2020. Now, one thing I do want to stress is when I have someone come into my office who had a felony conviction that's been reduced to a misdemeanor, and then I tell them that the court's going to treat it as a felony for eviction purposes, usually the first thing I get asked is, am I a felon? Do I now have a felony record? And the answer is, you do not have a felony record. You have a record of a misdemeanor conviction, and you should be reporting that accordingly. So when you go out there to apply for housing, and on that application it asks if you have a felony conviction, the answer is no, you have a misdemeanor conviction. So I think that's really important, and it's important for people to hear as well. Although the court's going to treat it as a felony for eviction purposes, you don't suddenly have a felony conviction. I also want to say for people like this, in this situation, for this example, where people are charged with a felony that are reduced to a misdemeanor, I frequently see on tenant screening reports that these cases, they are listed as felonies and not on misdemeanors. And that is something that should be corrected and can be corrected. Individuals have a right to contest the information or challenge the information as being incorrect on these tenant screening reports, and it's just a letter. And I frequently will send a letter on behalf of a client to a tenant agent or a tenant screening company saying, you're listing this as a felony, it should be listed as a misdemeanor. And really what I do is I just print off the register of actions from the court's website, circle where it says misdemeanor, and send that along. So I would say that if you're working with someone who has a felony conviction that's been reduced to a gross misdemeanor, a misdemeanor, or even dismissed, if they're applying for housing and they're getting denied, get a copy of that tenant screening report and double check to make sure that that they're listing that correctly, because that can be a difference between getting housing and not housing. Because I think there are more, the housing market's tight. Felonies are definitely, a huge barrier. I think misdemeanors are less so. Okay, and then I think this is my last example. If you're charged with a 5th-degree controlled substance crime last August, charges were dismissed in February, no subsequent charges or convictions. As long as this particular individual did not admit guilt, they can file today, and I would encourage them to do so. Okay, I'm just going to pause for a moment to answer a question. The question is, if you get your record expunged and you apply for a job or housing, and the application asks if you have a criminal record, can you check no? I'm going to pause to take a sip of water. So, again, the answer is it depends. Because, again, a criminal record expungement does not erase or eliminate the record. It just seals it. And I advise people when applying for housing, so now again, I'm talking about housing, I'm not talking about the employment context. If you've gotten a full criminal record expungement, which means that records both at the courts and the BCA have been ordered to be expunged or sealed, I think you are okay applying for jobs or housing and saying that you don't have a criminal record. You're applying for housing to say that you don't have a criminal record. When applying for jobs, because there's exceptions in the statute for certain jobs about can still access those records, I advise clients to tell them that you do, but the record has been expunged. I think most landlords and most employers, when they hear that someone has had their record expunged and gone through that process, they're okay with that. So the answer to your question, unfortunately, is depends. I think in the housing context, though, if you have gotten the record expunged both at the BCA and the court, you're safe to say that you don't have a criminal record. But I do want to just pause for a moment because Kristen is the housing attorney. Does what I just say cause anyone problems when it comes to public housing? And
yeah, I mean, it can't, short answer is it can create issues. However, they do, if it's public housing or some other type of assistance, they will find out about it anyway, I guess. And some of it also depends on the wording itself, because a lot of the public housing agencies have changed the questions that they ask now because of us threatening to sue them. Just because it'll say, like, they'll ask, like, have you ever been, like, arrested? Have you ever, you know, and so anyway, so it can depend on, I mean, we definitely don't encourage people to lie, but I would say that it depends on the question that is specifically being asked. We generally tell people that with regular landlords, what you said is true. Like, we usually say that you can just say that it's not there anymore.
Yeah. So I think when it comes to the public housing, what Kristen was saying is some of our clients have gotten into trouble by not disclosing it, even if it's expunged. I mean, I really think, I do believe that most landlords and employers, if you say, I was arrested, I was charged, I was convicted, but I've gotten it expunged, it can go, that usually can be enough. Any other questions waiting? I don't think I see any. Okay. Okay, so someone's eligible to file, that's great. And then the next thing I looked at, which I talked about earlier, is kind of the merit. And like I said, being able to file your criminal record expungement does not guarantee that you will actually get it expunged. There are 12 factors that the judge is going to look at and weigh in deciding whether to grant your request for a criminal record expungement. And I've listed the factors here. In the PowerPoint, this is 1 through 6. And I'm going to switch over now for those of you who are reading to show you, I'm going to attempt you but not be successful, through 7 through 12. And now I'm going to switch back, sorry for those who are reading, and kind of talk through them. So the two, I think, most important ones are 4 and 6, and I have them bolded here. Steps taken towards rehabilitation following the crime, and reason for the expungement, including the petition's attempt to obtain employment, housing, or other necessities. I think all the factors are important, and our appellate courts have told our district court judges who are reviewing these expungement factors that you have to consider all the factors, you have to go through them. But I really think courts are looking at the rehabilitation and the harm suffered. I think these are the two most important ones. The other factors are the nature and severity of the underlying crime, risk, if any, the petitioner poses to individuals or society. Arguments I've made under this, the risk if the petitioner poses to individuals or society. I've represented 2 or 3 individuals that had a diagnosis of bipolar, who, for whatever reason, when they had some misdemeanor offenses during like 3 or 4 misdemeanor offenses and convictions, during like a chunk of like a really distinct period of time, like a year and a half or 2 or 3 years. And when we go back and talk to that individual and explore what was happening during your life during that time period, we find out maybe they weren't medicating or they weren't, you know, seeking mental health treatment. And so one thing I've argued under this risk is in these cases, that individual now has supports in place, they're taking medication, they're regularly seeking help to manage their mental health symptoms as best as possible. And then I would argue that, you know, they're no longer a risk because they've, you know, they're doing what they need to manage that. Length of time since the offense occurred. I have seen people eligible to file, but the courts say, even though you're eligible to file, I think you need to wait longer. Again, steps taken towards rehabilitation following the crime. The example I gave about a couple of my clients with that bipolar diagnosis, I think, you know, finding that mental health treatment and support and stabilization can go toward that as well. Aggravating or mitigating factors. If you are working with someone who maybe is in things I've used as an example in this, these are not, I mean, there's other things you could use, but if I'm dealing with someone who maybe is a survivor or a victim of domestic violence and there's a DV angle related to why the individual, you know, committed that offense, I use that as a mitigating factor. Again, reason for expungement, including petitioner's attempts to obtain employment, housing, or other necessities. For dealing with a conviction, you have to show some type of harm, and that's what that's coming under. Harm that you have suffered as a result of this record being available to the public. The petitioner's criminal record. So this can be difficult for some people. The expungement statute requires you to disclose in the petition all of your entire criminal record in this state, other states, and other countries. They don't, not arrests that you were charged with, if you read the statute carefully, but you do have to disclose it all. Petitioner's record of employment and community involvement, recommendations of interested law enforcement, the prosecution or correction officials. I usually ask people to talk to the probation officer to see if they'll support the recommend or the expungement. Recommendations of the victim. So a victim of a crime does have a right to make a statement in court on an expungement petition. The amount, if any, of restitution outstanding. So this is one that can really cause low-income individuals problems. They're seeking an expungement, but they owe restitution. Really, you have to have paid that restitution off if you're going to have any success at the expungement, or you need to have a payment plan and been in that payment plan for a significant period of time and making payments on it regularly. I've had maybe, I can only think of one situation where I made the argument that this individual is on SSI, they have a limited fixed income, they're never going to be able to pay this off, they're judgment proof. There were some really great factors as well and facts for that situation. So and we got the expungement, so I don't know how much that particular thing relates to restitution, but generally, if someone owes restitution or fines on the particular case that they want to expunge, I tell them they need to pay it off or they need to start getting a payment plan before they file. And then other factors deemed relevant by the court, kind of a catch-all. All right.
Can I ask, yes, Kristen, even though I know they're two different things, but you said that unpayment of rent was a great thing to expunge. Do you have to have that rent paid off though?
So
would that, you know, it's similar? Or?
Yeah, it's similar. So we tell, I mean, there are certainly circumstances where we tell people, because sometimes landlords end up after they move out, like inflating the amount that's owed. Sure. So, I mean, that's not always true, but I definitely end up giving really similar advice to what Megan said. Like you need to either pay it off, you need to have a reason why you didn't pay it off. Like I'm contesting the underlying amount as being, you know, ridiculous. Or if you're in a payment plan, even then I think the payment plan thing might be a little bit of a stretch with rent. But if you had, I mean, if you could show proof, like I've, you know, been working on it, usually it's not as much possibly as restitution could be, because usually rent is not. I mean, landlords they're supposed to re-rent the place, so it's usually not, doesn't usually get that high, but yeah, that is similar advice.
Okay.
Can somebody request the report that the landlord received on background check?
Yes, absolutely.
Can somebody go to the BCA and get their report before they've been denied any housing?
Yes.
Do they have to pay?
Yes.
Even if they go in person?
So let me back up and answer. The question is, can you get what can you get at the BCA, basically is what the question. So just to make sure we distinguish this, if you are denied housing and that landlord ran a background check through a private company, you absolutely have a right to a free copy of your tenant screening report. The landlord does not have to give it to you, but they do have to give you the name of the company, and then that company has to give it to you. There is a great info sheet on this on lawhelpmn.org. And the link is the website's at the end of our PowerPoint slide, and it was earlier in Kristen's slides as well. That gives you a sample letter that you can fill out to get that. So that's the private screening report. As for the BCA, you can go to the BCA. Actually, you can go to the BCA's website now remotely, put in someone's name and date of birth. You need to have the date of birth, and you're going to get access to the public records. You can also go in person to the BCA, and they have computers there, and you can get access to the public records. I think there's a fee to print. The one thing I would say, though, is those are just the records that are available to the public. If you want to see all the records that the BCA has on you, you need to request a copy of your private BCA report, and it costs $8. And in fact, when I file a criminal record expungement case, I tell somebody to get a copy of their private BCA report, and I ask them to pay the $8 or find someone to help them pay the $8, because we have to disclose in the criminal record process your criminal history. And the best way to know that we haven't missed anything is to get a copy of that BCA report. And this has become such a practice now by people who, lawyers that do criminal record expungements, to include a copy of the private BCA report with the expungement petition, that judges are expecting it, even though it's not necessarily required. So I think it's helpful to get. So to answer the question, if you want to get all the records, so that can include arrests, it includes dismissed charges, it includes records that are maybe no longer public because they have fallen off at a period of time, you get your private BCA report, and it's $8.
If you go to the BCA to look up public records, is that only in Minnesota, or is that throughout the nation?
It's only Minnesota.
And you can get the exact same thing online?
Yes.
Mm-hmm. Okay. So the benefit is going to the BCA would be to pay the $8 and getting a complete report.
Yeah.
And that would include nationwide?
That would not include nationwide.
That's still only Minnesota.
It would indicate if there's a nationwide record.
Oh.
So it would include it would say that this person has records in other states, but it wouldn't have the full.
What does someone need to do besides bring $8?
Their photo ID.
Okay.
I would also say that frequently this comes up, and I'm going to anticipate maybe we'll get a question, and sometimes I have people come into the office and say, someone stole my identity, and a record that is not me is showing up saying that I was convicted of something, and I want to get a criminal record expungement. So the first thing that happens question is, why the heck did this happen? So when someone's arrested, and usually this is what I think happens, either someone has a really common name, the date of birth got mixed up. But what I actually see happen is someone is arrested, they're scared or whatever reason, or maybe they have ill intention, and they give a false name. So they give the police officers a name that is not theirs. If then the county attorney or the city attorney goes and charges that individual, the caption of the case sometimes still remains the state of Minnesota versus the wrong name. And unfortunately, in order to change that caption, so that's what becomes available to the public, there has to be like a motion filed in court, and usually it's not changed. So I actually see this more frequently than I would like. If that's your case, then you go to the BCA, you tell them that you think someone's using your identity, and what they'll do is this is free, you tell them you're using the identity, they'll take your fingerprints. and then they'll print you a copy of the private BCA report based on the fingerprints, and they give you a cover letter with a fancy seal on it that says, you know, this was taken based on fingerprints, this is the, you know, this extensive record that people have, or this person has in the state of Minnesota, this is it, we verified it on fingerprints, and then I've used that, or helped clients use that and take that to landlords to either correct their tenant screening report or say, hey, this is wrong, I have this letter, it's based on fingerprints, I have this fancy seal on this letter. I don't use those words, but it's amazing how far the fancy seal goes. So that's something someone can do if they're finding when they get denied, you know, housing, that something's coming up that's not them. And again, another reason to request that tenant screening report when you're denied housing, because you never know what could be on that, and if you don't request it, you're not going to know.
The other thing that I was going to say, which I think you did say, but just that if you, what I had mentioned before about contesting, if you think that there's something that's wrong on it, you have the right, so you can write a letter, and it can just be, it doesn't have to be a form letter or anything, but just a letter, and just to say, I think this is what's wrong on my tenant screening report. If they cannot verify that it's you, it has to come off. So it's not the other way. It's not like, oh, well, we think it's you. If they can't confirm that it exists, it has to come off.
And I would encourage you that, you know, I think people can do that on their, they can advocate by themselves for this on their own behalf. But if you've gone through this process where you've already requested that tenant screening report, you've asked that it be corrected and they don't take action, please call us. I wish it wasn't the case. I wish that individuals could advocate for themselves and not be a problem. But I think if that's happening, a letter with someone's signature that says attorney underneath it might do the trick. I wish that wasn't the case. I wish it could just be that these tenant screening companies follow the law and don't have to feel like they're going to get sued in order to do it, but call us if that's the case. Okay, so you're eligible to file, you have great merit of it, what's next? So, steps to filing a criminal record expungement. First, you gather the information, and this is something that really advocates can be very helpful with. So when I ask people to gather information, things I'm looking for, letters of support, so like from your probation officer, if you're working now from an employer, I think is really helpful. If there is some other people that are supporting you in your rehabilitation that can write letters of support, I think that's great. If after you completed probation or during probation, you completed some type of treatment or some type of vocational program or, you know, anything where you got a certificate, submitting that copy of that certificate. So gathering kind of your proof of the harm you've suffered as well and your rehabilitation. So the harm suffered could be letters from employers denying housing. I've had cases where someone's working with a housing advocate and for whatever reason they don't have those letters saying you've been denied housing, so I have the housing advocate, you know, write a letter about their experience. Next is you draft the petition. The petition is actually a signed affidavit or a signed statement of the person petitioning. So when I'm drafting that petition, I'm doing the writing, but it's really, you know, the client who signs it at the end. There's specific information in the statute that has to be included, but really this is an opportunity. The biggest part of this is telling that client's story, you know, what they've done for rehabilitation, and the harm they've suffered. So after the petition is drafted, you then have to serve it on any entity whose records you want to have sealed. If you do not serve it on an entity whose records you want sealed, even if the court orders that those records be sealed, the entity does not have to comply with it. So if, for example, you want records held by the St. Paul Police Office, or St. Paul Police Department to be sealed, and they're not served, even if the judge says St. Paul Police Department, seal your records, they don't have to comply. Service has to happen at least 63 days before the hearing, and this is why it takes so long. So at least 63 days before your hearing on the criminal record expungement, you have to serve all these parties, and service is done by mail. and you have to serve them with a copy of the petition and any supporting documentation that you file with the petition. It ends up being a lot of paper. So, for example, if I am going to help someone petition for expungement for misdemeanor theft, and the person was charged and convicted in Ramsey County, I will be at a minimum serving the Minnesota Attorney General, the Ramsey County Attorney, the St. Paul City Attorney, the Ramsey County Sheriff, the St. Paul Police Department, Ramsey County Corrections. That's just a minimum. If there is another agency involved, sometimes maybe it's a DHS licensing issue, then I'm serving the Department of Human Services. If the Department of Health is involved, I'm serving them as well. And the Department of Corrections. So basically, I'm covering all my bases is who you're serving. So it's a lot of paper. All right, so once you have, and this is where I see a lot of people mess up, is the service. So after you serve, you file with the court. There is a filing fee. You file in the county where the individual was charged. So if you're charged in Ramsey County, that's where you file it. If you're charged in St. Louis County, you file up to St. Louis County. After you file, at least 63 days after service, you have a hearing. What is involved at the hearing depends on the county where the individual is filing. Some counties, if they hear all the criminal record expungements at a certain time, so you're kind of waiting your turn. The hearing, generally the judge will ask the individual some basic questions. They don't take too long, 15 to 20 minutes maybe. It's not very expensive. It is possible that any of the entities that you serve with the petition, they have a right to show up and they have a right to contest the expungement and say that they object to it for whatever reason. If an agency objects, it does not mean that you won't get the expungement, but they have a right to do that. Some agencies will object beforehand by just filing a letter and not showing up. But it's important to know that just because someone objects is not an automatic you don't get it. That's for the judge to decide. And then finally, after the hearing, the judge has up to 90 days to make a decision. Most judges don't take that much time. I think it takes anywhere from, I would say, 30 to 60. And then you would hopefully get an expungement order saying, yes, we're expunging your record. However, under the Minnesota expungement statute, that order is stayed for 60 days before it becomes effective. And this is why it takes so long. You have an automatic 60 days on the front end of the hearing and at least 60 days on the back end of the hearing, not to mention the time of just gathering the evidence and putting it together. So that's why this process takes so long. So then hopefully you have an expungement order. Now that expungement order is limited, like I said at the beginning, that the court only has the authority to expunge records held by government entities. And so if you're doing this for housing purposes, and you know that there are tenant screening companies that have a record of that conviction, you're going to want to send that expungement order to all those tenant screening companies. Or if it's for employment purposes, you want to send it to the company that ran that background check. So, and they are required to remove it then. I'm going to pause. Are there any questions?
Okay.
Okay.
I have a question.
Sure.
Would there be a benefit to a person paying the fee for a tenant screening company to get their background versus BCA? In that, would the tenant screening company get something that would maybe have happened in another state?
I mean, it could show up in another state. Potentially, I mean, but it's not, what you get in the tenant screening report is not really very elaborate. It's usually just the sentence and the number. I mean, it doesn't give you really any other information. I think it could be, I mean, they are national, the tenant screening agencies are national. I guess I can't
What would be the purpose?
Well, let's say that you're working with somebody and some things happened in Chicago.
Sure.
And the person isn't either being honest with you or they can't remember. If you go to the BCA here, what you're going to get is Minnesota records, and you're wanting to find out what happened in Chicago. So would that be a way for you to find out how to get information about the Chicago.
I mean, certainly, yeah. I mean, certainly if you want to, if you want to pay and find it, I mean, you certainly can do that. I mean, so I don't know if there's, from the standpoint of someone who's going to file a criminal record expungement from the petitioner, I don't necessarily think that's worth someone's maybe potential limited income. If that's a policy that, like, an agency helping someone wants to do housing, I mean, I think that's up to the agency.
Is there a way to contact the BCA directly in another state to get the same kind of information that you could get in Minnesota?
Well, not every state has a BCA.
Okay.
So I don't know the answer to that. Or they may have something equivalent, but again, the BCA is a Minnesota-specific agency.
Yep. Might other states have like a bin court?
Yep.
Okay, so you could do some Googling and find out if that person's court records show up in another state.
Yeah, each state has different levels of access to court records online. I would have to say that Minnesota actually has more access than most states. And from our standpoint, we wish that there was less access to the public. But there are, if you try to Google and find out other states, just keep in mind that most states don't have as much access online as they do here. Or if you need to get online access, you have to pay a fee and become like a member or things like that.
I mean, you can usually, what Megan mentioned before, you can also usually call the clerk of courts and say, I'm trying to access, I'm trying to help somebody access their criminal records. How do I do that? Just because sitting for the bar exam, I had to do that for every single state that I lived in, pull my own records. So there is a way to do, there is a way to do that. Sometimes there's a fee. Sometimes you can do it online. Sometimes you can do it online with a fee or can't do it online at all. It's a very case-specific or, state-by-state type of thing. So.
Yeah.
It looks like there's a lot of not real ones, too, out there, right? I mean, it looks like, just I remember doing this as a case manager, lots of online sites that want to, I mean, is that true that,
find somebody.
Tell you if they're a sex offender or not,
I mean, I usually,
kind of
I feel like, anything that says .gov is a great place to start, that's usually when I'm trying to find that. I usually try to start there. I'm also licensed in Wisconsin, so I can say I know that what's called SpeakCap is the equivalent there. So there are definitely other states that have a really similar, but yeah, I would definitely not, pay money in some place that does not look legit.
Yeah.
We had another question come in. Can a careless driving with alcohol involved that happened over 7 years ago be expunged?
The answer to that is it depends. What is the level of the offense? Is it a misdemeanor, gross misdemeanor? I guess it could be a felony potentially. And then, based on that, how much time has passed? When did they complete probation? How much time has passed? And do they meet their requisite waiting period? And do they have any other convictions during that waiting period? So, unfortunately, the answer is it depends. And that's just if they can file, and then you have to look at kind of the merits of it, whether it's worth it. So, what can you do to help? Whether you're a case manager, or a social worker, independent skills worker, there's lots of different things you can do to help individuals who may be facing barriers to housing because of their criminal record. I think it's important to be proactive and help these individuals be proactive as much as possible. So realizing that a criminal record might be a barrier at the very end of your housing search is not helpful. So find out what those barriers could be now, and is it expungement a possibility, and seek out that legal help or that legal advice or that analysis sooner rather than later. Help individuals document the harm. This is really difficult for people. And people who are finding housing or do not have stable housing are constantly in crisis, at least the clients that we're helping. And so to go and ask them to keep track of another piece of paper, I think can be overwhelming. So if someone comes to me and they have a support system in place, I get that person on board as soon as possible to help them document the harm. You can also help them by providing rehabilitation documentation, stuff they've done through rehabilitation, or providing letters of support. Helping clients connect with resources. I strongly encourage you that if you have someone who would benefit from a criminal record expungement or eviction expungement, don't just give them our phone number. If you have the time and ability, please call with them. We, unfortunately, as lawyers, are scary. I don't think we actually are scary, but I think we're perceived as being scary, and I think having someone call with you can be very helpful. Because we have income guidelines, which we cannot get rid of because of our funding, you know, we're going to ask people questions. It can get, you know, helping people get through intake, and you can do a lot for your people you're serving. Again, coming to appointments with clients can be helpful, and then helping the clients navigate the system. So if you're going to help someone with, you know, get someone connected with legal aid for an eviction expungement or a criminal record expungement, whatever you can do to be there throughout the process is very helpful, whether it be just showing up to court with them to know that there's someone there to support them, if they're okay with that, coming to appointments with the lawyer, being there through the process could be very helpful. And where can you get help? So again, here's our intake number. On the Minnesota Judicial Branch, if you go to mncourts.gov, I think I have that right, go to Help Topics and then Criminal Record Expungements, you'll find court forms, and then lawhelpmn.org has a lot of help court forms. I do want to mention that both in the criminal record expungement area and the eviction expungement area, SMERLS has different levels of service. We offer clinics in both areas throughout our service area. So clinics are where people will show up and we will help them complete either, you know, do the analysis, are you eligible to file, and or help them complete the paperwork and file it, but we're usually not showing up to court with them. And then we do offer full representation, so helping someone from start to finish through the full process. So keep in mind that we have various levels of service that we can provide, and the level of service that we provide depends on many different factors. So again, any questions, here's our email. And our emails are, our general office number is 651-222-5863. You can ask for Kristen or myself. And then our intake line yet again. My preference, I think, would be if you have questions to send me an email, but please provide me with a phone number you can be reached at. I don't know what your preference is.
Yeah, that's fine. That's fine.
Mostly because, like all of you as well, sometimes we are difficult to get on the phone. So it might be more efficient just to email us. So I will stop talking and any questions people have.
And I would just like to make a comment now that if you are working with somebody and they have a difficult time knowing where to store some of the paperwork that's been involved, you can help them set up an account in hb101.org in the vault. It's free. All they need is an email address, and you could help them get a Gmail address. And it is a place where they could securely store some of those documents. You can download them, and it can be very helpful for people who are on the move, can lose things easily. They could share it with you securely, or you could keep it on their behalf.
Yeah, that's great, because I think, I'm sure everyone on this call is losing paperwork is a huge issue. Yeah.
And also, at least a copy of this PowerPoint will be available on hb101.org under the Partners tab. And if it did get recorded properly, and we're not sure if it did, but if it did, the recording will also be posted, but definitely the PowerPoint will be on there.
Sure. And if we have the ability, there are a couple other resources we can send as well to be posted with this. I can send a list of the felonies that are eligible for expungement, and then also some of those law help info sheets that we referenced. We can send those, so you don't have to click through the website, so that you guys can have those as well.
That would be great.
Any other questions on your end, Heidi? We're looking at different.
Nope.
Okay. All right. Well, with that, thank you everyone for participating. I know I won't speak for Kristen, but I think I can. And we think this is really important work. We think that housing can be open so many doors to stabilize individuals. Yep. And so anything we can do to help eliminate some of those barriers, we try to prioritize. And anytime we can partner with other community agencies, it really helps us as well. So please don't hesitate to reach out to us.
Yeah, I absolutely agree, especially I have had, and I know this is true for Megan, lots of people that just have one-off questions and fine with just, is this even something that can be expunged? yes or no, I'm perfectly fine with that. And if it is something that we'll do, you know, I can tell you, yeah, this is something we would take, like I'll make a new case for you or whatever. So I'm totally fine with that. We want to be as accessible as possible, especially for, we are so happy when there's another person involved. If there's another caseworker or someone, another person who can help us say, remember you have court at this time. It's really so much better for us to have another person to tag team with. So I just want to, again, emphasize that we are very much open for long or short questions or anything like that. So thank you very much.
Yes. Thank you all. Thanks. And the next Best Practices Forum will be August 20th at the same time, so stay tuned.